Hello again, everyone, and welcome to Marquette University Law School, the virtual Lubar Center. I'm Mike Goucher, and this is On the Issues. Today, we're talking with Rick Esenberg. He is the founder and current president and general counsel of the Wisconsin Institute for Law and Liberty. Some people refer to WIL, as it's called, as a conservative think tank. On its website, it says, and we're quoting now, "We believe in a thoughtful, vibrant, and principled conservative movement." Whatever you call it, there's no denying that WIL has become an increasingly influential player in Wisconsin politics and law, either through its litigation or through its policy research. Today, we're going to be talking with Rick Esenberg about all of that, but a reminder to you, the people watching right now, if you have a question for Mr. Esenberg, you can submit it to our Q&A function on this program, and we'll try to get to it a little bit later in this hour. Rick Esenberg, good to see you again. Thanks very much for being with us.
Nice to see you too, Mike, even if virtually.
I know, we're still a bit in that world. I wanted to begin by having you describe WIL's mission. How do you view the organization's role in public discourse today?
Well, so WIL started as a strategic litigation center. And our mission was to advance what we saw as the public interest in the rule of law and constitutionally limited government, individual liberty, and the promotion of a robust and vibrant civil society, one which forms people for freedom. So I think it's fair in the American context to call that conservative, although I would note that the conservative movement is a little bit more complicated than it was when we first started. One of the ways that I would put it, and I did so in an address to the St. Thomas More Society last night, is that we stand for our founding principles, which we interpret as classical liberalism. By that, I don't mean,
Right.
what we call the liberalism of the Democratic Party or MSNBC, but a commitment to those things that I mentioned: rule of law, limited government, individual liberty, free markets, etc.
You're now in your 10th year. Why did you think this was necessary? Why did you think there was a role for an organization like WIL?
Well, if you looked at the public interest legal landscape back in 2011, it was heavily skewed towards the progressive left. There was not locally, and there was, to a lesser extent, nationally, the same amount of resources devoted to the promotion of this particular view of the law. And so we thought that it would be useful, both in terms of developing the law and with respect to promoting public discourse, to have an organization that would be committed to the vision that I just described for you. And as time has gone on, we've sort of added a think tank component. So we have people who are not lawyers. They're involved in doing research. When we come up with a quantitative study that uses statistical techniques, we have statisticians that do that. That's not lawyers. Lawyers are generally people that, if they would have been able to handle calculus, they would have went to med school. So, and I count myself in that category.
So was there a point where you said, look, we need to add the public policy research component for us to have even a greater impact?
Sure, because we couldn't litigate our way, and we shouldn't be able to litigate our way to the public policy that we would like to see. And so oftentimes there will be an issue, and there will be a litigation component to it. A good example is there's been a controversy, an ongoing controversy, over whether or not the Milwaukee public schools are making vacant buildings available for the use of private choice schools, as leasing it to them, selling it to them, as the law requires. There is a research component of that, which attempts to answer the question whether those allegations are true. And there's also a litigation component which seeks to answer the question as to whether or not the law as it is written has been complied with.
So you just cited an example, the MPS example of a case and an issue that you choose to explore, how do you make those decisions? How do you decide which legal cases to pursue, which policy aspects to pursue?
Well, the first thing we ask is whether the case is within mission or not. The second question that we ask is what impact will this particular case have? Our resources are not unlimited. We have to pick and choose. As much as we might like to see ourselves as sort of free-ranging crusaders for justice who seek to right all wrongs, we can't be that. And so our cases tend to be ones where the impact will not be limited to the parties involved, that the case will move the law in a way which we think will be beneficial generally. And so, is it within mission? Does it have the type of impact that we would like to see? Is there a probability of success? I don't, think that it's a good use of our resources to tilt at windmills. And, that's more or less the considerations that we go over every time that we talk about bringing a case.
Because of your mission, which you stated earlier, a lot of people associate you with being very close to the Republican Party, being helpful to the Republican Party. And I'm wondering if you have ever discussed the possibility of playing against type, taking on cases that might have frustrated or angered Republican lawmakers. Did you think about that during the formation, or that is just counterproductive to your mission?
No, I think we have played against type. We have represented isthmus in open records cases.
The Madison publication, correct?
Yeah, the Madison publication, which I think is well to the left of center. During the Trump administration, we didn't bring a case. There wasn't really a case to be brought, but we were very critical of things like the emergency order to repurpose funds to build the wall. We thought that, and still do believe, that if we're going to build a wall, and we don't have any position on that, Congress should be the ones to appropriate the funds. And our separation of powers, it's Congress that decides to do that, not the President of the United States. We've taken that position during Democratic administrations, and it's important for us to take it during Republican administrations as well. We were critical of the decision to extend certain corporate benefits to Kimberly-Clark during the Walker administration. We've called out the Republican Party on attempts it made to restrict the open meetings and open records law in ways that that we thought would not be particularly useful. When there was a campus freedom bill that sought to address the disruption of speakers on campus, we thought the way that bill was drafted by the Republican legislatures was insufficiently protective of First Amendment rights. We put out a report that said that, and I could go on. I think that we may be seen as close to the Republican Party because the Republican Party tends to be more aligned with the issues that we care about. But what we care about are the issues and not the politicians.
You mentioned Kimberly-Clark, and it made me smile a little bit because I wondered if there was any consideration, for example, of Will getting involved in the Foxconn deal, which there were a lot of legal issues kind of surrounding that. There were different points of view that were strongly held. Did your organization ever think about, as controversial as that might have been, getting involved?
Well, that would have been difficult. There wasn't a particularly good case to be had with the Foxconn situation. There were people who may have had. I want to make sure that I phrase this in a way that's general enough that I don't violate anyone's confidence. But there were people whose legally protected interests were arguably violated by the Foxconn deal, but they were. I think, more interested in having higher levels of compensation than they were in validating the principle. And for a private law firm, that's just fine. For an organization like us, or I imagine public interest organizations on the left, if the client isn't committed to the principle, right? If the client is willing to compromise the principle for money, that's not a good case for us, because you can go to lawyers that will do that for you. You don't need to go to a donor-funded public interest law firm for that. I will say, however, that a case that we had pending at the time of Foxconn, which challenged certain aspects of the tax increment financing law.
In Eau Claire, correct?
Yeah, up in Eau Claire, would have probably rendered the $10 million Mount Pleasant TIF unconstitutional. And we advanced that issue before the Wisconsin Supreme Court. The Justice Department at the time, Republican-led Justice Department, intervened in the case, argued against us. Unfortunately, they prevailed and we did not.
You made an interesting comment earlier. You described, I think, the conservative movement as being more complex today than perhaps it was a few years ago. And you mentioned where you were willing to challenge the Trump administration. How difficult is it to challenge someone like Donald Trump in a world where people are quick to rail against you if you seem to be breaking from what they view as your proper position regarding the president?
So of course, we would not challenge a particular individual, because as a 501c3 organization, we cannot advocate for or against candidates. So when it comes to Donald Trump or Scott Walker or Joe Biden, our position is that we don't have one. But it is true that there has been, over the past 10 years, a greater, and again, I talked about this last night after the Red Mass, there is a greater willingness on the part of the Republican Party and certain elements of the conservative movement to be favorably disposed towards big government solutions. And we don't necessarily share that orientation. And so there can be disagreements between us and people who have more purchase politically than they used to have, with respect to things like, I'll call it crony capitalism. They would have a different word for it. And a more muscular use of the government to accomplish policy ends.
Let's talk, Rick, about a few of the issues that your organization has been involved with that are front and center today in Wisconsin. And we'll begin with redistricting. Your organization thinks that, well, most people agree that ultimately the drawing of new maps will be determined. The final decision on new maps will be made by a court, whether it's the state Supreme Court, whether it's federal courts. You have said, and your organization has said, that you think this is a proper purview is the Wisconsin Supreme Court. Why do you think if somebody has to ultimately draw the maps, it should be the state Supreme Court?
Well, because we believe in the rule of law, and we believe in the promotion of the federalist system that our Constitution establishes. So if you take out your Constitution and you read it, it becomes quite clear that the drawing of legislative maps is a state function. Because it is a state function, not just the Wisconsin Institute for Law and Liberty, not just the Wisconsin Supreme Court, but the United States Supreme Court itself, in a case called Groh, has said that this is a state legislative function, and when it is necessary to review these maps in court, the preferred forum is state court. And the preferred forum is state court because in our federalist settlement, our Constitution gives this task of drawing legislative maps primarily to the states. And so that's a position that we've sought to vindicate. The second principle that we've sought to vindicate is legal neutrality. And we've taken the position that that the question of whether maps favor or disfavor a single political party is effectively non-justiciable, because by non-justiciable, and I know that there's a lot of law students out here and they know this, and I learned when I was a law professor that you never talk down to law students. They don't like it and they shouldn't like it. Is one that courts can't address. And the reason for that is that determining the right degree of favorability for a political party of a set of legislative maps is inevitably a political determination. And we don't think courts should be involved in making that. And so our position is that the courts should not. We took that position in an amicus brief that we filed in the United States Supreme Court in the Ruscio case. That position eventually prevailed. That would be our position in the redistricting litigation that's pending now. And after that, we have really no position other than the maps should be, as the Constitution requires, equal in numbers, same number of people in each district, and reasonably contiguous and compact.
Of course, the pushback, which you're very familiar with, is that it was federal courts in 1982 and 92 and 2002 that ultimately drew the maps, and that they were drawn by people who are not elected. And if you have the state Supreme Court draw maps, perhaps you're adding to the perception that it's not just a body that determines the law, but it's also a body that has a political role. What do you say to that?
Well, I mean, that's really a political question, isn't it, for the people of the state of Wisconsin? The Constitution gives this task of drawing maps to the states. The states then decide how they want to do it. In Wisconsin, we've determined that the legislature draws the maps. The Wisconsin Supreme Court determined in the mid-60s that that product of the legislature has to be signed into law by the governor. So we have a situation where the legislature can draw the maps, the governor has to accept them. If the governor vetoes them, then there has to be enough votes to override. And everybody thinks that the matter is going to go to court this time around because they don't believe it possible for the Republican legislature and Governor Evers to agree on a set of maps. They think the governor will veto whatever the legislature passes, and the legislature will not have enough votes to override the veto. If I was a betting person, I would go heavy on that proposition. So we're going to go to court. It is not a 1982, 1992, 2002 position that this is a state function. This is a long-standing recognition by both the federal courts and the Wisconsin Supreme Court itself recognized. It had drawn maps in the 60s, hadn't done it more recently. But in 2002, it recognized in a case that was brought by then Assembly Speaker Scott Jensen that it had the primary responsibility for reviewing these maps, but it didn't do it because it decided that there was a federal case that was sufficiently well along and that they couldn't really catch up and they didn't have a process in place. And so, but they said that they would put a process in place later on. They didn't do that. We asked them to do that at the beginning of this year. They essentially said they didn't need to. They apparently were right about that, because when we asked them to take the case just recently, they decided that they would take the case as an original action. And so it's pending. Now, there are people that are very critical of having an elected judiciary, but that's not a new position in the state of Wisconsin either. I mean, we've had an elected judiciary since we became a state. And whether or not you or I might like an elected judiciary, the people of the state of Wisconsin are not about to amend their constitution to do away with that. And so the people have decided that they believe that elected judges can be impartial. And, whether I agree or not doesn't really matter. That's the way it is.
I asked that question in part because
incidentally, I think they can. I don't want to leave the impression that I disagree. There are certainly conservative and progressive judges but they're not conservative or progressive in the same way that conservative and progressive politicians are. I think all judges, or most all judges, see themselves as committed to making decisions in the way that lawyers make decisions. And in my view, they do that. And I think that the common refrain now that the Wisconsin Supreme Court is a political institution that just makes political decisions is absolutely wrong. It's a slander against the justices, and it's simply not true. And if you look at the results, I think that's borne out.
I asked the question in part because I think there were, as I was reading, back in, maybe 10, 15 years ago, I was reading some of the comments of justices at the time, people who I would consider to have more of a conservative judicial philosophy. I saw Michael Gableman, the former Supreme Court justice. They seemed a little leery of going down this road and getting into the discussion of maps. They just thought maybe there's a danger there. Were they wrong, or why do you think they had that concern?
On a human level, I can understand the concern, right? I mean, who wants to be thrust into this maelstrom? I can understand that you would want someone to take this cup from you, which is the term, incidentally, that Justice Prosser used. But I just don't think it works that way. I think that they ultimately came to recognize, as they had said in the Jensen case, as the United States Supreme Court has said in Groh, that this is their responsibility. And as much as, and I think this goes back to what I just said about, the justices having a sense of obligation, as much as they might like to duck that responsibility, they weren't about to do it.
Hey, I mentioned then Justice Gableman. He's in the news a lot. So as long as I've got you, I'll ask you, what do you think of the election audit that he is overseeing? As an attorney, as the representative Will, what do you think of that?
Well, I don't know much about it. We don't have anything to do with it. I don't know exactly why he's subpoenaed records. I don't know what he's intending to do with them. I would only say this. A legislative subpoena is not a judicial subpoena. So he's acting here as counsel to a legislative subcommittee. And so although I think it is, I understand that there are people who say, why would you subpoena records if it's clear that Joe Biden carried Wisconsin in 2020? Why would you subpoena records when it is quite clear that the election can't be contested and there's no basis for prosecuting anybody in connection with the election? And my response to that would be that would be a good set of arguments if it was, District Attorney Mike Gableman, but it's not. It's lawyer Mike Gableman, who is serving a legislative committee, and the legislative committee has oversight over the election process. And I certainly can conceive of issues that arose during the 2020 election that are worthy of legislative consideration. So, for example, we use drop boxes.
Right.
Many municipalities use drop boxes in the 2020 election. Drop boxes really aren't authorized under the law. Now, they may be a good idea, they may be a bad idea, but it seems to me that whether or not we're going to continue to use drop boxes and how they might be used, right? What type of oversight would you have? It's a fair issue for the legislature. We had a certain amount of controversy about private funds that were given to local governments to run an election, and we have, there was a partisan skew in the distribution of that money. Should the legislature do something about that? Should it be permitted for private parties to help fund our election administration process? And if so, how should that work? And again, without necessarily taking a position on the details of that answer, that seems to be an appropriate legislative question, and maybe the legislature wants to know more about it. So I guess, I don't want to pass judgment on what he's doing until I see more about what he's doing. I don't really know.
But it does sound to me, Rick, like your organization has some concerns about the election integrity case. You just mentioned election integrity issue. You just mentioned a couple of cases where Will is involved. You also tried to purge more than 200,000 names from the voter rolls because of people you thought had probably moved away or were no longer living at those addresses. That was unsuccessful. But clearly, while I don't hear you necessarily saying you disagree with the results of the election, you do think there are issues to be explored.
Well, sure. Look, it's not, with respect to the voter roll case, it's not just me, right? I mean, Jimmy Carter said a long time ago that, we need to have accurate voter rolls. Federal law requires that a state maintain accurate voter rolls. And if you think about it for a minute, it's not hard to imagine why. You don't want to have a lot of names on the voter rolls that don't correspond to eligible voters living at the particular address that they have. And so the question is, what processes are we going to undertake to maintain voter rolls that are as accurate as possible? Now, we believed that because the administration and the maintenance of the voter roll had moved over the years from individual clerks to the Wisconsin Election Commission, that the Wisconsin Election Commission now had an obligation set forth in statute to address reports of voters who had moved, and that this responsibility was triggered by a report from a consortium named ERIC that Wisconsin pays to be part of, which had identified certain people as likely movers. And it didn't require that they be automatically purged from the voting rolls. It required that there be a notice sent out, that there be an opportunity for the voter to respond to that notice. And if the voter didn't respond to that notice, then the voter's name would be removed, but there would be multiple opportunities after that for that person to renew their registration, including by presenting themselves at the polling place on election day. We thought that that was a reasonable interpretation of the statute, but I acknowledge that the statute was a bit of a kludge because, it was the product of amendment over a number of years. And as I said before, a change in the way in which voter rolls are maintained in Wisconsin. And so we were not successful in that case. I personally don't know whether that would have had a partisan impact or not, because my understanding is that the way that you could be falsely identified as a mover is if you had registered a vehicle at your vacation home, if you had registered a vehicle in your business name, or if you had purchased a car for your college-age child and registered it at their college address and not at your home address. And, that's a relatively wealthy group of voters, and I wouldn't want to cast a surmise as to how it is they would vote.
So when Democrats say to you, these are legal actions that are pure and simple designed to tamp down Democratic votes, to tamp down Democratic turnout, what do you say to those folks?
Well, they're not, because I mean, I just I just described the only people that we would be concerned about in the voter roll case would be those people who were listed as a mover on this report and had not actually moved. Now, the report is overwhelmingly accurate, but it's not perfect. And so, although there would be an opportunity for those voters to respond or remain on the rolls, that would be the group of people that we are concerned about, those who had been falsely identified. And so, when you saw people write things about how the people on the mover list were, disproportionately resident in Democratic areas, that's meaningless, because it's also the case that, people in places like Madison and Milwaukee are more likely to move. So we would expect, if the list was accurate, that more people from Madison and Milwaukee would be on it. But we're not concerned about the people who have actually moved. We're concerned about the people who haven't. And as I just indicated, that is a that is a smaller group of people, and it's a group of people who would have had to have been on the list as having moved to a new address because of something that they themselves submitted to the government. That's the only way you get on the list. And I just identified, I think the three most likely ways that you would get on that list, inaccurately. And I can't say who that group of people would vote for. So I don't know that I don't know that the case had any particular partisan impact.
Let's talk for a moment about mask mandates, because your organization has challenged a number of these, especially the Dane County Health Department issuing mask mandates. I think one of Governor Evers' orders for a mask mandate. Why did you feel it was necessary to do that?
Once again, this was a rule of law concern for us. We did not make in either the case that challenged the governor's mandate or the more recent challenge to the Madison impact, any argument that people had a liberty interest in not wearing a mask. What we said was that if we are going to impose this type of requirement, it has to be done in accordance with the law. So with respect to Governor Evers' mandate, the concern we had was this. The law provides that the governor can declare a state of emergency. During that state of emergency, the governor has extraordinary powers. He or she can issue any order to protect person or property, right? Essentially, the governor becomes, both the maker of the law and not simply its administrator. And so because of that, the legislature quite appropriately, and this is not the Republican legislature, the law has been this way for years, says that state of emergency is delimited in time, can only last for 60 days, and it can be rescinded by a joint resolution of the legislature at any time, and can only be extended by a joint resolution of the legislature. And Governor Evers, what happened, as you recall, that he declared an emergency in March 2020, and the emergency was about to expire in early May. He either didn't think or didn't want to try to get the Republican legislature to agree with him about extending that emergency. Maybe he thought they'd say no. Maybe he thought that their terms would be different, but whatever, for whatever reason. He then decided to use a different statute to extend what was at that time sort of a lockdown order, if you will. And we came out with a statement. We said, we don't think the governor can do that unless he proceeds by a rulemaking. The legislature then ultimately brought a case, and the Wisconsin Supreme Court in May of 2020 said that's right. The governor has to proceed by rulemaking if he wants to use these other legal provisions to continue these extraordinary COVID restrictions. For whatever reason, the governor declined to proceed by rulemaking. I'm sure he would say that he thought the Republicans would, block him, but there was a time when political actors kind of took their positions and fought it out in public. He decided not to do that. What he decided to do instead was declare emergencies in series, one after another. So the 60 days would expire, he'd declare a new one. The 60 days would expire, he'd declare a new one. And that's how he imposed the mask mandate. Nobody should want that. Nobody should want a governor, Republican or Democrat, to be able to rule by decree by declaring emergencies in series. Because if you look at the statutory definition of emergency, just about anything could be an emergency. It could be COVID, to be sure, but it could be climate change. It could be urban, crime. It could be illegal immigration. It could be, issues that are favorable to the left. It should be issues favorable to the right. We don't think that that's our separation of powers or our statutory law permits that. And so we brought an action, and it made, one argument. You can't declare emergencies in series. And because of that, your mask mandate is ineffective. Now, Ultimately, after some fits and turns, we participated in the oral argument in that case. The Wisconsin Supreme Court agreed that you can't declare emergencies in series. Now, it was still open for the governor to have a mask mandate if he wanted to. He just would have to proceed by rulemaking. He chose not to do that, so there was no mask mandate. But our interest was an interest in enforcing the rule of law and structural requirements in the exercise of government power. And that's really it.
You know, it's an interesting challenge because you described the rule of law and what you felt was what should not be happening in the state of Wisconsin. And yet there were people in Madison and Dane County who were saying, we are in, for modern times, an unprecedented emergency. We have, we're up to nearly 9,000 people dead in the state of Wisconsin, 800,000 plus cases of COVID, 700,000 plus deaths nationwide. I saw the mayor, I think not too long ago, the mayor of Madison essentially said that she thought, and I think I'm accurately attributing this to her, that she thought that Will was undermining the efforts, their efforts to keep people safe and healthy and alive, was her comment. That's a pretty strong statement. Do you feel that anything the organization did contributed to what we have seen in this state?
No. So on the merits, I think that statement is hyperbolic and irresponsible. I mean, there's simply no evidence to support it. It certainly may be that a government may want to have a mask mandate as well as a number of other tools to respond to a COVID pandemic. I think that the mask mandate was fetishized and to some degree, both sides tended to exaggerate its impact. That the people that didn't like the masks, sort of saw them as a badge of tyranny. The people who liked the masks saw them as far more effective than any extant research supports. And so both of them had a very exaggerated view of what was at stake in the mask mandate itself. But let me concede for a moment that that the mayor is right, and a mask mandate in Madison or a mask mandate in the state of Wisconsin was very important. There was, as I say, a way to do it lawfully. One simply had to engage a process called emergency rulemaking. And at any time that could have been engaged. And the reason that it wasn't done, I suspect the reason that the governor didn't do it is he thought that the Republicans would block him. I'm not sure that's true. The Republicans never repealed the state of emergency during 2020, so I'm not sure that they would have blocked any rule that he might propose. But the problem with all of that is it's stunningly irresponsible for a governor to say, I'm not going to do what I think is the right thing because I don't think those other politicians will go along with me. I think there was a time when we would expect our governor, our president, or our Congress, if it worked in the other direction, to do what they thought is right and to challenge the other side to impose it and have this debate in public rather than simply point fingers, almost as if it was more important to have a talking point, political talking point, where one could blame the other party than it was to get the right set of policies in place. And so, if we should have had a mask mandate that we didn't have, it's because the proper procedures weren't used by the people who wanted to have one. And then if the Republicans would have blocked them, then they could have sought to make the Republicans pay for that politically. But they didn't even make the attempt. And so I think the statement is factually questionable, but I also think that it avoids the elephant, statement by a Democrat, but I'm not using the beast in that way. It avoids the obvious question is if the governor thought that this was so necessary, then why didn't you do it in the right way?
Let's spend our final few minutes here talking a bit about schools and education reform. I know that's a topic, a subject that's very important to your organization. As I say that, a reminder for people watching out there live with us, if you have a question, please submit it to the Q&A function, and we'll try and get to a few of those in just a moment. But let's talk about schools. And there's been legislation in Madison recently. The Assembly's passed it. And this is really, I think, an effort to have some impact on what's being taught in our schools, what's being taught to teachers and administrators in our schools, and programs that exist in our schools. And I know the words aren't in the legislation per se, but this, I guess, would go under the umbrella of critical race theory, and that there are concerns about what could be taught to our students in the schools. How do you feel about that legislation? Does that make a difference? Why is it important in your mind?
Well, we are a registered lobbying organization. We took no position on that bill. I will say that personally, I think the bill needed work. And the reason is that it attempts to do a difficult thing. The problem here is not one of the First Amendment, because when we're talking about school curriculum, we're talking about government speech, right? And the government has to decide what it's going to say. So teachers who are employed by the government have no right to teach what they want, regardless of what the school board directs them to teach. This is government speech. They have the right to say whatever they want outside of the school context. But when we're in the classroom, we are conveying the curriculum that the government has chosen to convey. And, there are restrictions and, legal limitations on that. But the real problem here is not one of the First Amendment, it's one of policy. And it's a very, very tricky thing. I don't think in principle it's wrong for the government to say that we choose not to convey and to teach certain concepts to our children. We, choose, not to convey concepts of collective guilt. We don't think the 1620 Project is good history, whatever it is that they want to put into the bill. But the problem is describing that limitation without the risk that it will be applied to things that we don't want it to be applied to. And so you mentioned, I guess it was a list of terms that one of the legislators mentioned. It. It's not in the bill, it's not in the law, and it's a bit of a red herring. The way that people have responded to it, it's sort of meaningless what he said. But the problem that you're identifying is a very, very real one, because while we may not want, I certainly would not want the government to teach certain concepts which are associated with critical race theory about collective guilt, about attitudes being racialized, about racial essentialism, where the most important thing, or seemingly the most important thing that we can know about a person is whether they're Black or white. I wouldn't want any of that. On the other hand, I wouldn't want to pass a bill where the schools could not teach about slavery, about the run-up to the Civil War, about failed Reconstruction, about the Civil Rights Movement. All of those are critical and essential parts of American history that need to be taught. And so the question is, how do you craft a bill that gets that just right? And I think it can be done, but it's an extraordinarily difficult thing to do. And I'm not sure that I don't think that this particular bill quite got there. And I don't think that, although I don't think that the comments that were made at the hearing were particularly meaningful, I also don't think that they're helpful because they were just too broad in general. I get what he was saying. I get why he said it, but I don't think in the context of this legislation it was helpful. So what we did instead is we proposed a curriculum transparency bill. And we said, all right, let's do this. Let's require school districts to make public the curriculum that they're teaching to students. And then parents can then, and voters can look at that and they can decide what they want to do with it. And so that was the approach that we took. Whether or not you could go further and limit CRT and CRT adjacent instruction. It's not,
Right.
People say it's kind of a shock to say that critical race theory isn't taught in school because students in 6th grade aren't asked to read Kimberly Crenshaw and Derek Bell and the impenetrable jargon that constitutes critical race theory in the academy. But there are concepts that are taught that are derived from that. And I think it may be possible to limit that by legislation. I think it is, but it's really hard to do.
So a lot of, we've seen this issue come up locally on the local level. We have seen recall elections, and I saw that one of the attorneys for Will was helping with a recall effort, at least giving some advice, I think, and correct me if I'm wrong, to a recall effort.
I think you are wrong.
Okay, well, so this is Mequon, and this is
I know what you're referring to. And
yeah.
The problem in Mequon, we have nothing to do with the Mequon recall.
So no one has ever talked to any of your attorneys about what's going on there?
No. What happened was this, and I live in Mequon, and if you drove around Mequon during the run-up to the recall, you would see that in public places, there were people who had
Signs.
tape, and they set them up, and they had signs that they affixed to the table that says recall, Mequon School Board. And the Mequon, the city of Mequon initially took the position that those signs were prohibited, that they violated the Mequon sign ordinance. And our position was, if they do, then the Mequon sign ordinance is unconstitutional, because the government cannot tell people that you can't have a table with a sign in a public place that says, come here and sign this petition. Doesn't matter whether it's for a recall, whether it's for, any particular issue or public policy initiative. And I think we were right about that, because when we challenged the city on that, they went into closed session and they came out and said, oh, never mind. We were wrong about that. We're not going to do it. And the people that were promoting the recall went on to have their signs. Now, I guess they got enough signatures. There's going to be a recall election in November, but I don't even. Certainly, Will has no position on whether the Mequon-Thiensville School Board should be recalled or not. I'm not sure what my position is on whether the Mequon-Thiensville School. I'm going to have to study that issue.
I think I remember you not being a fan of the recall of Governor Walker. I think back in 2012, you were not sold on that being a good idea.
I wasn't. I just think that recall is something that should be reserved for relatively extreme cases. And I'm not even sure that Gavin Newsom should have been recalled for going to the French Laundry. Yeah, I'm sure you've been there, Mike.
I have never been there. You can rest assured of that.
Well, maybe we'll go sometime.
Let me see if we have some questions from our audience, and then I'll wrap it up with one final question. But let me go to Hillary DeBlois. She is our program manager here at the Lubar Center. Hillary, any questions from people watching today?
Good afternoon. Yes, there is a question. Thank you. Rick, are there any constitutional issues raised with an employer retaliating or discriminating against an employee based on the vaccination status?
There could be some legal issues that are raised. So, first of all, if there could be some issues, there isn't a constitutional right not to be vaccinated or not. Generally, there may be a constitutional right to have some form, or at least to have some form of religious exemption considered if your objection to the vaccination is religious. And there are, as I understand it, some people who do have religious objections to the vaccination. In particular, there are people who believe that, I think one of the vaccine lines was developed using an old stem cell line that was that had fetal stem cells, and that obligation wouldn't apply to a private employer because there would be no state action involved. But that private employer might nevertheless be subject to anti-discrimination laws, anti-religious discrimination laws that would require it to consider an exemption. And then whether it had to provide one or not would be subject to a balancing test. But there has not to date been recognized a general right not to be vaccinated. And in fact, the existing law in Jacobson would support a right of vaccination, although I would caution that Jacobson was decided in 1905, and the way in which liberty claims were evaluated then is not the same. And so, it's possible that the court might recognize a right someday, but it hasn't recognized one yet.
Hillary,
Thank
any
you.
other questions?
No, thank you both. That completes the questions.
Okay, thanks, Hillary, very much. Rick, couple final points. Take me 10 years out. What do you see the role of will being at that time? Does it continue to grow? Does it take on a national profile? Where do you see it in 10 years?
Well, Will has, for the first time in the past year, started to do national cases. And we did this in particular as part of our Equality Under the Law project, where we thought that there was some extraordinary legislation being passed that conditioned government benefits on the race of the beneficiary. This is something which has been highly disfavored, almost to the point of prohibition under our constitutional law. And yet it was an integral part of certain COVID relief provisions in the bill that was passed at the beginning of the year. And so we actually got the first two orders that stopped a Biden administration program that conditioned restaurant relief funds that were paid to restaurants that were, shut down during the COVID pandemic on the race of the owner. And we got that order in Tennessee. We also got the first order that stopped the conditioning of farm loan relief on the race of the farmer, although that case happened to be up in Green Bay, Wisconsin. And so I think what's happened at Will is we have developed a really extraordinary and excellent litigation capacity. And this has nothing to do with me, it's my younger colleagues. I always say, and I think everybody at Will now is going to get sick when they hear me say it, because I've said it so many times, that I've reached a point in life where a big part of my job is to take credit for what younger people do. And we have an extraordinary group of litigators at Will who I would put up against litigators really at any law firm in the country. And so I think that capacity will assert itself, and there will probably be an element in which Will becomes more of a national player. But it's important for us not to lose our Wisconsin focus. I think that there is tremendous value, and this value exists whether you want to promote the objectives of the right or the objectives of the left, of having an organization like Will that focuses on a single state, because states are where we make a lot of policy. And so I don't expect that Will ever lose its Wisconsin specific focus. Do I think that Will be bigger than it is today? I do. Will is bigger than it was last year, and it will be bigger next year. I mean, at some point, I think that growth the growth of anything eventually ends. But I think that that for the foreseeable future, there will be manageable growth at will.
And do you consider it flattery that there is now I guess, a progressive organization based in Madison that also goes to bat on issues that they feel are important to progressive values?
Well, I mean, I think I said in the newspaper that that they say that imitation is the greatest form of flattery. I think that I'm willing to be flattered by it. We don't much agree with law forward, but I will say that they are lawyers who I think are good and who I respect. I think they would say the same thing about me and us. But, in reality, I suspect that, when something is a good idea, it's just a good idea. And I think that, folks who have that particular political perspective came to recognize that. Maybe we help them see it. If so, I guess they can send me a Christmas card. But we look forward to the debate as the years go forward.
Rick Esenberg is the President and General Counsel of the Wisconsin Institute for Law and Liberty. I really appreciated the conversation, Rick. Thanks very much for being with us today. And thanks to everybody who tuned in for this. This will also be available online, the taped version of this later. So let your friends know. Thanks again to everyone watching. And again, thanks to Rick Esenberg.